Well, good afternoon, everyone, and we are very excited to host this important discussion about the public charge rule and immigrant access to public benefits in 2025. And my esteemed colleague Eleanor Sullivan will be um, providing just a nice in-depth description of the policy and what's changed about it, what hasn't changed. We're going to go until 2 o'clock today, and it will be recorded. And it will be available. The slides will also be made available to everyone that registered. I don't know if you can go to the second slide here. Yep, that's the one. Yep. Before we get started, I want to just make note that we do have this webinar available in Spanish. If you want to access the Spanish audio, just click on that globe on the bottom. It says interpretation, and you can select Spanish as the language. Also, if you'd like to ask questions, we're going to be monitoring the Q&A box throughout the webinar. So just use that to ask questions. And if you'd like to ask questions or make a comment live, you just click that raise hand button. And again, just a reminder on this, it is being recorded. We will share this to all registrants and also share the slides. Next slide. I guess before we get started, I just introduce myself. My name is Deepak Madala. I am a director here at Virginia Poverty Law Center in the Center for Healthy Communities. VPLC itself is an organization that's been around since 1978, working to dismantle systemic barriers that have kept low-income Virginians in poverty. At our center, at the Center for Healthy Communities that Eleanor and I work under, we focus on programs like Medicaid, Virginia Insurance Marketplace, SNAP, TANF, Social Security, and just try to work to make sure they're adequately serving the people that they're meant to help. With that, I guess we'll get started. I'll introduce my colleague Eleanor. Eleanor is a Medicaid policy analyst and Enroll Virginia Navigator at Virginia Poverty Law Center. Before joining us at VPLC, she was a navigator at CVLAS for several years. And before that, she actually practiced immigration law for nearly 6 years with Catholic Charities as a DOJ certified immigration specialist. With that, I'll turn it over to you, Eleanor. Thank you.
Thank you so much, Deepak. And thank you everybody for being with us this afternoon. So we are going to talk a little bit about public charge. We'll talk about public charge and public benefits and how they intersect. So for a quick overview of what we're going to go over today, we'll sort of recap on what public charge is for anybody that hasn't been steeped in this over the last several years. We'll talk about what public benefits actually trigger public charge and what don't. We'll talk about various types of immigration statuses that are already exempt from public charge and don't have to worry about it under any circumstances. We'll talk a little bit about who's at risk from triggering public charge. We'll talk some about what can change with public charge rules. And then we'll talk a little bit about, if you are a service provider, if you're a community member, how do you message about public charge to a lot of people who are in your community or to your clients, given that this has been an area of anxiety for a lot of non-citizens over the last few years. So to go ahead and just recap a little bit about what public charge is. Public charge is a test that immigration officials apply to immigrants when they're applying for lawful permanent residence, which you may know as a green card, or for a visa to enter the US. And the public charge test examines whether somebody's going to rely on public support in order to survive. And if a non-citizen fails to pass the public charge test, i.e. the immigration officer decides, yes, you're going to have to rely on the government to live here and survive, then the immigration official can actually deny their green card or their visa application. And I think historical context is somewhat important here for understanding why public charge was created. It's really an Ellis Island relic. It's been part of immigration law since the 1800s, and it was created to keep people out. Um, you know, in the 1800s, a lot of government officials denied entry to unescorted women who were going to be subject to public charge. So today, how do you pass this public charge test that is still part of our immigration law system, and that's been around for so long? So there are really two ways. And to bring it kind of back to that Ellis Island context, public charge has had the concept of a sponsor for a very long time. So if somebody comes to the United States, if there's an American here that says, yes, I am sponsoring this person and I will help be responsible for them, then they were much more likely to be let into the USA. This has not changed since the 1800s, really. If there is a non-citizen that is applying for a green card through a family petition or through an employer petition, that relative or that company actually signs an affidavit of support with US immigration saying, yes, I'm sponsoring this person, and yes, I have income over a certain threshold, so this person will not be relying on the government because I can guarantee that they'll be able to survive otherwise. And by signing the affidavit of support, in most instances, immigration officers now consider that to be sufficient to meet the public charge requirement. And then the person can pass that public charge test and get their visa or get their green card. So that's the bulk of how public charge works for many, many immigration applicants. One of the second elements for folks that are going through a family or an employer immigration route is they do need to show that they're not using public benefits that count for public charge. Because right now there are a handful that do. You know, if somebody is receiving TANF or maybe cash assistance from a local program, that can be counted as public charge, and that's something they then have to rebut in order to get their green card. The second way that folks can sort of pass the public charge test is to not be subject to it at all in the first place. So I already said that, you know, US immigration has had this concept of sponsors and of public charge since the 1800s. The United States after World War II and after the Holocaust did have a big pivot in its immigration law, and they created a whole new category of humanitarian immigration statuses. So these would be refugees, these would be asylees, because enough people in the US government at that time realized that if you had folks coming to the United States from abroad who were fleeing persecution in their home country, we shouldn't turn them away because they didn't have a sponsor. And so, you know, in the 1940s, 1950s, the US started having these humanitarian immigration statuses like refugees. And so the United States said, you know, these people are coming here for humanitarian reasons. They don't need a sponsor. And so they're exempt from public charge. They don't have to worry about it at all. These folks can rely on the government if they need to. They can use public benefits if they need to, and it won't affect their immigration status or their ability to stay in the US whatsoever. So to get into some of the details, I want to review a little bit. Right now, as of May of 2025, we have not seen big changes to the public charge rule compared to what it's been for the last few years, which is very good news. Because at the moment, it's really just a small handful of public benefits that count for public charge and therefore have to kind of trigger that test and become a little bit of an obstacle to someone getting a green card. The most of those other public benefits that aren't in this very select list are no problem for immigration whatsoever. So the benefits that are subject to public charge mostly sort of fall under the category of the government is paying to, you know, keep you in a nursing facility, or the government is paying cash to help you survive. So for example, long-term care Medicaid, if it is for somebody living in a nursing facility, does count as public charge. Important note here, if you work in the Medicaid world, this does not include long-term care Medicaid for in-home care. You know, if you have somebody that's a senior citizen and they have long-term care Medicaid to get a home health aide come to their house and, you know, bathe them once a day, that does not count for public charge at all. It's no problem for immigration law. Supplemental Security Income, or SSI, also counts for public charge. TANF, because it's cash-based, also counts for public charge, and so do some forms of state and local cash assistance. But other than those really big four categories, pretty much every other form of public benefit does not trigger public charge, is completely exempt from that consideration. And that really includes sort of all the rest of our health programs, all the rest of our food programs, housing programs. So very importantly, for those of us at Enroll Virginia who do a lot of Medicaid work, Medicaid and CHIP, which we call FAMOUS here in Virginia for kids, exempt from public charge. Marketplace insurance and any subsidies through the marketplace are exempt from public charge. So is Medicare. SNAP benefits, formerly called food stamps, are exempt. WIC for women, infants, and children are exempt. School meals, Head Start, Section 8 housing, unemployment, and several others are all exempt. So non-citizens, if they're able to access these benefits, can go ahead and enroll for them. And that will not affect their immigration status. It will not prevent them from getting a green card or becoming a US citizen. At the moment, under the rules as they are, these benefits are simply not a problem. And that sort of leads us to the second piece that I was talking about. You know, we had the first set of folks that could pass the public charge rule as long as a sponsor has signed that affidavit of support and they're not using long-term Medicaid, TANF, SSI. And then we have that second category of folks who fall under a humanitarian immigration status, and they're therefore completely exempt from public charge to begin with. So those would include asylees and refugees. These are folks that are in the United States because they've faced persecution in their countries of origin. Individuals who have U visas and T visas. U visas are for victims of crimes that have cooperated with law enforcement. T visas are for victims of trafficking. Those individuals as well are exempt from public charge and don't have to worry about it. Special immigrant juvenile status recipients are exempt from public charge. This is a special status for youth or children that have come into the United States and a family judge has determined that there have been abandoned, abused, neglected by at least one parent. They're also exempt from public charge. Cuban and Haitian entrants, there have been special rules for those individuals for several decades that exempt them from public charge. VAWA, which you'll see in a lot of regulations referred to as battered non-citizens. These are individuals that have been married to or have another qualifying relationship with a US citizen or a green card holder who is abusive. Those folks are able to petition for their own green cards and they're exempt from public charge. Ukrainian parolees and Afghan parolees who came to the United States under those special programs are exempt from public charge. And then we have lawful permanent residents. These are folks that already have green cards. And these folks with green cards, in order to get those green cards to begin with, they've actually already passed a public charge test, right? So the public charge test is behind them. And they don't have to worry about public charge again, unless they happen to have departed for the United States, stayed abroad for more than 6 months, and then are seeking to re-enter on that green card. If that happens, they can be subject to an inadmissibility screening where the government says, hey, is there any reason that we can keep you out? But other than that, you know, again, green card holders have already satisfied that public charge test when they went through their green card application process. So all the folks that you see here on this screen, they can have any of the public benefits, including the ones that normally would trigger public charge, like SSI or TANF. They can have those benefits and it won't be of any consequence to their immigration status or to their immigration future. Again, because they're just categorically exempt from public charge. It just does not apply to them. So that kind of leaves us with the question, we reviewed the list of benefits that are subject to public charge, and really it's only a handful that are picked out to have public charge apply to them. We reviewed the humanitarian immigration statuses that are already exempt, and it's a good number. So that kind of leaves the question of who's actually affected by the public charge rules as they are today. And honestly, the answer is very few people. Um, Almost no non-citizens need to worry about using public benefits now, either because it's not a public benefit that is considered to count for public charge, or because they already have an immigration status like a refugee that doesn't have to worry about public charge to begin with. And so once we filter all of that out, it's really a very small list of immigrants comparatively, who need to worry about accessing public benefits and how that'll affect their immigration status or immigration future. So I think we'll go ahead. This is one of our halfway points. So I think I'll go ahead and pause here and see if there are any questions in the chat.
Yep, thanks, Eleanor. And again, just a reminder, we are recording today's webinar, and if you would like to access the Spanish language for the presentation, just click on that globe, and that'll access it through Amber. So there's a question, I think just a clarification. What does TANF stand for?
Yeah, TANF is temporary assistance for needy families. This was previously called welfare, and it is cash assistance for families that qualify. Very stringent program, very stringent rules. It's quite difficult to qualify, but it is cash assistance.
Then a question about the cash support version of that. So can you specify what kind of cash support from local organizations or state would count for this?
Honestly, it really depends on the locality or the state because it can be very different from locality to locality and state to state. Generally in Virginia, we don't have very many. We put this on the list because there are other states that really have more robust assistance programs than we do here in Virginia. But at the moment, I think mostly in Virginia, most of what you're going to run into is TANF.
Yeah, though I'll add a note to that is that there are some localities doing UBI programs. Those are the Universal Basic Income, and that's the direct cash assistance. That's where those may fall under this, but it would be a case-by-case determination. I know that like Arlington and Alexandria and Richmond are some examples of that, but I think just reach out to us and we can help clarify. But those are some examples of the cash assistance. Another question just about this is something you might get into later. Is there asking about public charge process is different from the D3 waiver is the question, and is the process feasible for nonprofits to sign off on an affidavit for public charge for DACA recipients?
So that gets more into immigration law, which we probably can't address. It's a little bit outside of the scope of this webinar. I would say for very general legal information, in general, it's organizations can't just choose to be a sponsor. Generally, in immigration law, you have to have a qualifying relationship with an immigration applicant. So you have to be an immediate relative in order to do a family petition for them. You have to be a company that is sponsoring them for work if you're going to be an organization sponsoring them. So just as general legal information, it's not wholly optional, even if an organization is so inclined. And I'll also note that just as a point of general legal information, DACA is not a status that requires sponsorship.
I think two initial questions, then we can continue on. One is, can U.S. citizen children with parents who are subject to the public charge still apply for programs like TANF or the other programs that are listed under the considered public charge?
Absolutely. Yeah, we were going to chat about that a little later, but it's such an important point. Yes, if there are US citizen children and the parents are undocumented or the parents are non-citizens themselves, the children can have benefits and it has absolutely no impact on the parents or their immigration status. That's because the children are the only beneficiaries. The parents might be on the case only as household members because obviously 2-year-olds are not going to be buying their own food or taking themselves to the doctor. And so you have to have a adult or guardian managing that. So non-citizen or undocumented parents might be on those benefits just as kind of the manager and household head, but they are not receiving the benefits for themselves. And so that would not trigger public charge or present any kind of immigration barrier or obstacle.
Thank you. I think this is the last question, is just a clarification about the TANF again, if programs are funded by the TANF program, would be getting assistance from those programs count as public charge?
I think we would have to look at the exact circumstances to answer that, but I think in general, probably not. I think somebody would have to directly apply under their own name using their own information and income eligibility and immigration eligibility in order for that to count as public charge.
Yeah, thank you, Eleanor. That's great. And yeah, we'll still reserve some time at the end to answer additional questions and do follow up as well. And we'll be running until 2 o'clock.
Perfect. Thank you, Deepak. So to continue a little bit, like I just said, as of today, under today's rules, there are almost no non-citizens that need to worry about the consequences of using public benefits. If they qualify for those public benefits, then generally it's almost always safe to apply for them and use them. I do think in 2025, that does bring up a question of, okay, but what can change? That's the case for May. What might be different in June? So we did want to address this a little bit because there are certain ways where public charge rules are very much set in law, which makes them much more difficult to change. And then there are other ways where public charge rules are really more regulatory, which means that US government agencies have a lot more flexibility in what they can change and adjust without having to go through Congress. So we'll talk about this a little more. So in general, the rules about the humanitarian statuses that are exempt from public charge. So once again, these are your refugees that are just not subject to public charge, your asylees that are totally not subject to public charge, your Cuban Haitian entrants that don't have to worry about public charge. Those rules are statutory, which means that they come from laws that Congress has passed and the president has signed. And that also means that in order to change them, Congress would have to pass a new law to do so. And changes to this particular type of law are not filibuster proof, meaning that in order for Congress to say, no, we're going to change our minds, refugees are subject to public charge, and we're going to look at what public benefits refugees have used. In order to accomplish that, the Senate would have to have a 60-person majority to defeat any possible filibuster challenge to that bill. And this is very difficult. So what this means is that I think, nobody knows what's going to happen over the next several years, but it is more likely than not that this list of immigration statuses that are humanitarian and therefore are not subject to public charge, it's much less likely that that's going to change. Probably next year and in 2027 and in 2028, refugees are still going to be exempt from public charge. So that's a piece of good news. What is a little more flexible are the list of benefits that count for public charge. So again, this is what I went over in the beginning when I said, yes, TANF and SSI can trigger public charge. Most forms of Medicaid, SNAP, WIC, those don't. So that set of lists, that separation is actually subject to regulatory change, which means that US government agencies, like for example, US Citizenship and Immigration Services, can decide to publish a new rule and say, no, we've decided, we've changed our mind. Now SNAP does count for a public charge test. And now WIC does count for a public charge test. Agencies, just as long as they go through the appropriate kind of rulemaking and publishing and public comment processes, agencies do have that flexibility. Which means that the list of benefits that could count for public charge is more likely to change relative to the list of humanitarian statuses that are just probably going to continue being exempt. This, of course, doesn't mean that agencies are not going to be subject to lawsuit. If parties decide that a rule that they passed is unfair or unlawful, but agencies do have a lot more flexibility here. And we did see that in the past. I'll go into this in a few minutes because I think it's really important to have some of the historical context here again. But US agencies in 2019 did make changes to public charge rules. And a lot of the anxiety that we've seen in immigration communities and among service providers stemmed from that set of 2019 rule changes. So what if that happens going forward? What does that look like? I'll say, first of all, absolutely nobody knows for sure what will happen. We don't have a crystal ball. Nobody else does. So we could see changes come down the road. However, once again, I think there are a couple of things to keep in mind. And I think these things are very important to keep in mind. Again, if you are doing any kind of messaging about public charge to communities, if you're a service provider, if you're in an affected community, there are certain things to keep in mind because they do restrict how much public charge rules can change. And I think that's very important for letting folks know that it's very likely they can keep their public benefits and not decide to voluntarily drop access to them, right? So one of the things that I think is very important to keep in mind, like I said, even if agencies make more benefits count for public charge, even if school meals all of a sudden becomes a ground of public charge, you still have that pretty long list of humanitarian statuses that are still going to be exempt, right? So if you had a refugee that received free school meals, even if free school meals become subject to public charge, the fact that they're a refugee means that they can just bypass that public charge test to begin with, right? So I think that's very, very important for immigrant communities to understand. I think the other thing we want to talk a little bit today about is historical context. So once again, US agencies did make changes to public charge rules in 2019. But one of the things that was perhaps underreported at that time that was very, very critical is that there were really significant carve-outs, even among those more stringent rules. And we'll get into that in just a second. So to go back a little bit in time, to give you a little bit of a historical snapshot of what public charge has looked like over the last 25 years. For the most part, over the last 25 years, you've only had that small handful of public benefits that have counted against someone when it comes to the public charge test. So again, TANF, SSI, Medicaid for a nursing facility, those have counted for public charge since 1999. And it's been very consistent that everything else, like normal Medicaid and FAMOUS and SNAP, have not. This was a little bit different for about 2 years, and that was in between 2019 and 2021 under the first Trump administration. And during this time period, rules were changed to be more restrictive. More benefits counted. So for example, SNAP was moved over from the column of does not count for public charge into yes, it does count for public charge. But what was so interesting about this rule is that these changes had almost no actual effect on who could use public benefits or who could be denied a green card for using them. And the reason for that is they were mostly redundant. So for example, yes, SNAP became countable for public charge tests, right? But to get SNAP in the first place, you pretty much have to have an immigration status that already makes you exempt from public charge. If you were somebody that had maybe DACA or temporary protected status, yeah, SNAP would have affected you if you applied for a green card, but because you only had DACA, you couldn't get SNAP to begin with. So it was kind of this funny circular thing where these rules sounded really, really awful and really, really restrictive. But because of how the United States really restricts access to public benefits to begin with, not that many people actually were legally affected. Most people that already qualified for public benefits could have kept using them. And most people that had public benefits, when they went up for a green card, those public benefits didn't affect them whatsoever. So that was sort of the actual legal impact, which was, again, very minimal. But this new rule did have a very significant chilling effect on immigrants. Um, it was a very complicated rule. And so the way that it got messaged publicly and the way that maybe misinformation spread on social media is more along the lines of, oh no, having a public benefit will hurt you. And so what we saw is that a lot of folks voluntarily disenrolled themselves from public benefits, even though they didn't need to. So I want to go through a little bit of how this works. Because again, if you are in the public benefit space, if you are working with non-citizens, if you are in an immigrant community, this is just context that's really important to know as you continue to talk to folks about this over the next few months. So let's start out with some of the carve-outs. So even these more stringent 2019 through 2021 rules still had very significant exemptions. For example, they totally exempted Medicaid for pregnant people. They totally exempted Medicaid for kids. And they were pretty generous in their definition for kids. When they said kids, they meant anyone under 21 who had Medicaid. So that could actually have been people with Medicaid expansion who were 19 or 20. Emergency Medicaid for non-citizens was completely exempt from public charge. So, pardon me. So these are already really big categories, right? These are already really significant carve-outs. And already we're starting to see that these rules really have more holes than they even have substance when you have that many people already taken out. Then we had the situation for non-pregnant adults. And while in 2019, US agencies said, yes, something like, say, Medicaid for adults who are not pregnant does count for public charge and admissibility. It could be a problem if you have Medicaid as a non-pregnant adult and you apply for a green card. But this gets back to that circularity I've been talking about, where really, in order to qualify for non-pregnant adult Medicaid to begin with, you have to have a status like refugee, asylee, green card holder, Cuban Haitian entrant. And if this sounds familiar to you, that's for a good reason. It's because these are all of our humanitarian immigration statuses, right? And these folks are already exempt. So again, while this rule said that, yeah, Medicaid for non-pregnant adults, that can really be a public charge problem. In actuality, to get Medicaid to begin with, you already had to be exempt. And so most people just kind of bypassed that whole new rule. It affected very few people. There were a couple of statuses that are not exempt that could get, say, adult Medicaid, like withholding of removal. But again, the number of folks that have withholding of removal, have full Medicaid, and then also are eligible to apply for a green card, it's really not very many people. So at the end of the day, you had this public charge rule that said, oh yes, this benefit counts and that benefit counts, and this could affect your eligibility for a green card. But then when you started winnowing it down, once you got to the adults who were not pregnant, and so they didn't meet an exemption, and then the adults that qualify for Medicaid and also aren't public charge exempt, and then they're also applying for a green card. Once you filter out all those exemptions and all those circumstances, it left very, very few people who are actually affected by this public charge rule. So once again, that was kind of the legal reality. That was not necessarily what was broadcast or the message that a lot of non-citizens received when they heard about public charge. So in 2019, what happened is that even though very few people were actually affected, the way the messaging worked is that what a lot of people heard is that no immigrant can use public benefits. Or what they heard is if you're a non-citizen and you use any kind of public benefit, if you're on Medicaid, if your kids have SNAP, If you apply for a green card or apply for citizenship or try to petition for your relative, it's all going to be denied. And none of that was actually true. But because that's how things were being messaged, that's how information was being passed word mouth to mouth. That's what people were reading on social media, unfortunately. What happened is a lot of people lost benefits, not because they had to, but because they decided to either disenroll themselves voluntarily because they were afraid, or they decided not to apply for benefits, even though they were eligible, and having those benefits would never have affected their immigration status in any adverse way. So that really leaves us between a really significant gap between the 2019 rules and what they legally accomplished, and then the 2019 rules and what they accomplished through intimidation. So I think that means, once again, if you're a service provider or you are part of an immigrant community and are talking to other folks about this, I think it makes it very, very important that those of us that are doing messaging know all of those details and are able to communicate them to be able to combat some of that misinformation and to be able to combat some of that fear. So we wanted to kind of recap, if you're going back into communities, if you're talking to clients, if you're talking to other nonprofits, there's a certain set of messages that I think are really important to get across. So to recap, one of the most important messages is just to remind people, as of today, there have been no changes to the public charge rule. The public charge rule looks today like it did in 1999, like it looked like in 2005, like it looked like in 2023. And that means that most public benefits just don't count for public charge. Medicaid doesn't, marketplace plans don't, Medicare doesn't, SNAP doesn't, WIC doesn't, free school meals don't. We still have that sort of small subset of cash-based assistance like SSI, TANF, Medicaid for institutionalization that do count, but that is the same today as it was in 1999, right? The other thing that I think is really important to communicate about public charge is that humanitarian status piece, right? The fact that humanitarian immigration statuses are exempt from public charge and that this is actually very difficult to change. And that will include asylees, it'll include refugees, it'll include UNT visas, it'll include VAWA recipients and applicants, your Ukrainian and Afghan parolees, Cuban and Haitian entrants, SIJS. All those folks are exempt no matter what benefits that they use. None of that will present a problem to them as they get a green card. And then, of course, lawful permanent residents or green card holders have already passed that public charge test. I think another thing to communicate about public charge, this already came up through a question, but it's such an important point, and I want to reiterate, is that benefits for U.S. citizen children don't affect parents, even if the parents are completely undocumented, because those benefits are for the kids. I think this is an especially important point to communicate in Virginia because I'm sure many of you on the call have seen notices of action from departments of social services that say, yes, you've been approved for SNAP or you've been approved for Medicaid, and the parent's name is right up there, big in the corner. One of the things I think it's important to tell people is that the parents are always going to appear as the head of household on benefits because once again, kids generally are not managing their own medical care. You have to have a parent that's doing that for you. And so they are the head of household for the benefit, but they are not necessarily a recipient, and it is absolutely no problem that they are the head of household. As long as the undocumented parent or whoever parent is not getting a benefit that they are not eligible for, it presents absolutely no problem, and there is no reason for parents to be disenrolling U.S. citizen children or other eligible children from benefits. I think another important point, and this is a little bit more new, is that public charge is not just about using public benefits. Public benefits are one factor among a whole set of elements that compose the public charge test. Immigration officers examine a lot of factors when determining whether or not someone passes the public charge test, including, very importantly, if somebody is getting a green card through a family member or an employer, that affidavit of support that the sponsor signs. That's often more important than anything. So even if somebody is among the very rare number of people that have ended up on a public benefit that is subject to public charge, and they aren't part of a humanitarian status, and they're applying for a green card, even if you have one of those very rare individuals, it is possible to overcome a presumption of public charge from having used a public benefit, right? So that individual could show, other positive factors like their employment, their educational history. Their sponsor could have a very significant amount of income that they put on that affidavit of support. All of those things can actually overcome the negative factor of having used a countable public benefit. So using a public benefit is not the end of the public charge story, and it is not, folks I think who are concerned about that should talk to a good immigration attorney about how to overcome any public charge concern, because it can be done. And then I think lastly, we did want to give you some resources, given fear in the community, given how much immigration is in the news these days. I think it's really important to have trusted external resources to help you provide some of this background to folks about public charge, to encourage non-citizens to keep their benefits when they're still eligible, or to encourage them to apply when they qualify, right? And not let public charge concerns deter them. So we have several resources here we wanted to share. There's a really great Erlinda letter. And this is a letter that the Protecting Immigrant Families organization wrote as a template that folks can use for immigration attorneys to explain public charge and public benefits to immigration attorneys, because it is true that some folks go to immigration attorneys and immigration attorneys say, absolutely no public benefits at any point, it'll hurt your immigration case. And that is not already always true. And so a lot of these profits, like Protecting Immigrant Families, have found themselves doing a lot of legal education to immigration attorneys about that. And so this is a way, this Erlinda letter is a way to kind of make that easy. Protecting Immigrant Families also has really great information that's just kind of introductory about public charge. They have flyers and resources for clients, and it's all translated into multiple languages, which is really nice. There's an interactive guide where folks can, enter their immigration status, they can enter the public benefit they've used, and they can see whether or not there's a potential public charge concern, or they can see if their immigration status is exempt. Again, if they fall under one of those humanitarian categories. And then there's something there in historical context, just reminding folks that in the past, even under the most stringent public charge rules, there have still been really big carve-outs. Medicaid for pregnant people and children and emergency Medicaid have still never triggered public charge, even when those rules were at their very strictest. So these are all live links, and we will distribute these slides after the webinar. But these can be really, really helpful, if you run into somebody that has public charge concerns or doesn't know how to talk to their attorney about it. And then we also wanted to give a note about our own help that we have available here in Virginia. Again, we are part of Enroll Virginia. We have navigators and other partner organizations throughout Virginia that help folks apply for Medicaid and for marketplace coverage. And all of us are able to talk to our clients through public charge concerns if they come up. So if you or anybody is concerned about this, or is a non-citizen that wants help making any of these applications, please feel free to call our general line. You'll enter your zip code, and then you'll get connected to a local navigator. And with that, I think that's all we have for everybody this afternoon, and we're ready to get to the next set of questions.
Thank you so much, Eleanor. Let's see here. Yeah, one good important question here is, will I be considered a public charge if I'm only applying for benefits but don't end up using them?
Yeah, that would not count. If somebody has applied for public benefits but is denied, or they withdraw their application and they're never actually a recipient, that would never count, at least under any rules that have existed previously and not under current rules. You have to actually receive them.
I think, and then I think just a further clarification that, for specific statuses and when their kind of applicability to the public charge rule. So does it include asylum applicants, parolees, and DACA recipients?
Yeah, so it does get a little complicated. It sort of depends first on whether you're asking whether or not public charge applies to those applications or would apply to, say, a DACA recipient applying for a green card. So, for example, if you have somebody who's applying for DACA, public charge is not part of the DACA eligibility test. Public charge doesn't come up at all if you're applying for DACA. If a DACA recipient then applies for a green card, the public charge test would come into play. And so then a DACA recipient would have to pass a public charge test in order to get a green card. And then I'll add as a sort of further caveat to that, at the moment, DACA recipients are not eligible for any public benefits as DACA recipients. And so, I think again, it's sort of a moot point. If you're not eligible to get Medicaid or SNAP or SSI or TANF, you can't use those benefits. And then that's not going to be a problem for you when you apply for a green card and have to face public charge, right? In those situations, public charge is always going to boil down back to that immigration affidavit of support and sponsorship for the green card.
Another question about, I guess the clarification, SSI. So they're saying, why is SSI counted as a public charge? I think it's just a clarification between SSI versus Social Security. Difference between those.
Yeah, so first to clarify the difference between Social Security and SSI. Social Security, of course, are the benefits that you get if you are retired or if you have Social Security disability. Those are the monthly benefits you get. SSI is a supplemental payment. If you're on Social Security for retirement or for disability and that monthly Social Security is really very low, then the government, you can apply for SSI, which is a supplemental payment, to then make your monthly benefit a little more robust. And one of the differences is Social Security payments are based on what you have paid in taxes yourself as you've worked. SSI is considered to be a public benefit, unlike Social Security, because it's not tied to money that you've paid into the system yourself when you were employed. And for that reason, SSI is considered to be a cash-based public benefit. And so SSI counts for public charge, and Social Security, again, is not really considered a public benefit because it's based on your own work history and contributions you've made to the Social Security pot.
Question from Sharon. Does this apply to all states or is this just Virginia?
No, this is public charge is all national. This is national immigration law, and so it can't vary from state to state. States don't have the power to make changes to immigration law. That being said, of course, different states have different public benefits, so that can change the landscape a little bit, but the rules in terms of what humanitarian statuses are exempt and what benefits do and do count, that's going to be consistent because this is national federal policy and not state policy.
Gotcha. Yeah, and I think, and there's several different questions asking about this. I think that distinction between what is and what is not actually considered a benefit that is covered by public charge, and particularly around Medicaid, because there is one type of Medicaid that is currently subject to public charge. But there's questions about marketplace insurance. Let's see here. Virginia Medicaid generally, I think there was a question there. And I think the other question is famous prenatal. That's the more important one because many undocumented Virginians do qualify for that program.
Yeah, great question. So in general, almost any health-based program is exempt from public charge. So normal adult Medicaid, exempt from public charge. Famous prenatal, exempt from public charge. Medicaid for children, exempt from public charge. Marketplace and any subsidies on the marketplace. So advanced premium tax credits, exempt from public charge. There's only one very small, narrow program for Medicaid that does trigger public charge. And that very narrow set is long-term care Medicaid that pays for somebody to be institutionalized in a nursing home. So if somebody has Medicaid, but Medicaid is not paying for their nursing home, they're fine. They don't have to worry about public charge at all. Only those folks where Medicaid is paying for them to be in a nursing home, only that type of Medicaid will trigger a public charge concern. Every other health program, Marketplace, Medicaid, Famous Prenatal, whatever program it is, kids, adults, aged, none of the rest of it is a public charge concern.
Thank you, Eleanor. And we still have a good 10 minutes, so feel free to keep putting in some questions, and we'll try to get through as many as we can. Kind of a couple of questions that came on around kind of looking to the future and current, recipients who might be considering changing to a green card in the future. Kind of receipt of, benefits right now that they are eligible for, like emergency Medicaid, and whether they would be subject to it in the future, and if that that is sometimes a reason why attorneys, immigration attorneys, do say just in case not to do it, and kind of your take on that, and thinking about just a little bit what we might see in the future.
Yeah. So once again, nobody really knows what's coming down the pipeline in the future. There's just no way for anybody to tell. I think in general, if there is any kind of rule change, I think there is a chance that emergency Medicaid would still be exempt from public charge because it was exempt from public charge considerations even during that stringent 2019-2021 period. Another thing to keep in mind is even if there is a change, a lot of times these rules don't go into effect retrospectively. If the government were to just decide that, yes, Medicaid for non-pregnant adults is now going to be a public charge concern, most of the time when agencies write those rules, they say starting in July of 2025, and only benefits received after July of 2025 will count. That's often the way it works. Again, there's no guarantee that that will happen in the future, but I think it is always possible that if any agencies try to make retrospective changes, there could be a chance they'd be subject to pretty quick lawsuit. So again, nobody knows, but I think there are several things that in the past and rules generally around regulatory rulemaking might prove somewhat protective to that. And then I think a final thing to remember is for most public benefits, eligibility is really restricted. Again, to be eligible for Medicaid as a non-pregnant adult or for SNAP, you have to have an immigration status that most of the time is already a humanitarian immigration status. And so you're already exempt from public charge. So even if the rules change and become much more strict, just like in 2019, there are still a lot of people that will simply not be affected because they couldn't get public benefits to begin with, right? Or they're getting public benefits and they are a refugee and they're exempt to begin with. So once again, you sort of have that circularity. And even if rule changes sound really, really bad, when you start digging into the particulars, it's very likely that once again, fewer folks would be affected than is immediately apparent.
Thank you so much. And I'll also add to that too, that, that's why we're doing today's presentation, to give everyone kind of a baseline of what the rule is today. But we do plan to keep up with this. And so if things do change with respect to the public charge rule or even immigration benefits in general for in Virginia, we will be sharing that information. I know everyone provided their email address when you registered for this webinar, and we plan to kind of share out additional opportunities for more trainings as they come, as they're needed. question. Let's see here. Yeah, I guess clarification on SSI question. How would the SSI affect a parent who is receiving SSI for their child? Would this?
It would not. If the benefit is for the child, if the child is the only recipient and the parent is only on the case as really the guardian, sort of the household head, it wouldn't affect the parent at all. The benefit has to be for the individual in order for the individual to be affected by it.
Another really good question from Blanca asking about just making a comment too that many individuals are afraid to apply because of a fear of their information being shared. Can you talk a little more about that of what protections are in place at DSS or Medicaid agency for their information, application information?
Yeah, absolutely. So right now, there are rules about information sharing between health agencies, like the marketplaces and like state Medicaid agencies, like our Department of Medical Assistance Services here in Virginia, and how they can share information with other government agencies. So right now there are sort of legal firewalls in place, legal rules that say the information somebody submits on a Medicaid application can only be used for the purposes of Medicaid administration. And that is law, that is statutory. And then there are regulations below that currently that say, and this information cannot be shared for the purposes of immigration enforcement. So right now, the rules and the laws are very clear on that. Of course, in today's environment, who knows what agency is going to be accessing what information if it's not lawful? But the rules are in place to prevent that from happening. And I do think something that's important to point out here in Virginia is Virginia has a very fractured public benefits landscape. Our public benefits are still administered county to county, city to city. We have 120 different localities, and they all have their own caseworkers and their own data. And so there is, although that has made the lives of many of us who help with Medicaid applications very difficult over the last few years, there's a protective quality to that. Because, if, for example, an immigration enforcement agency were to go looking for data, they might have to dig over so many places and so many sources that it could be really difficult for them. So that's about what we know today.
Thank you, Eleanor. We do actually have one person that had their hand raised. Let's see if I can. Got just a couple more minutes here, so I'm able to do that. Julie, can you are you able to speak and let us know what your question is? We'll go. Julie, feel free to put your question in the Q&A, and we're happy to. If we can't get it on today's call, we will definitely follow up for any questions that we were not able to answer live during the webinar today. Any additional questions here? The question from Maria that just came in was saying that dealt with the mother last year who doesn't have legal status in the US, but whose newborn was eligible to receive Social Security disability. But the Social Security office kept telling her that she couldn't receive the baby's Social Security payment because she didn't have immigration status in the US. The baby's father ended up being the one who received the payments because he is the legal status. Is this correct?
Yeah, so that's not really a public charge issue. That's really a question for an attorney that does Social Security. So feel free to email us and we can give you a referral to the local legal aid closest to where the family lives. But that's really a Social Security matter and not a public charge matter.
We just have one more minute left, but I think, just thank you so much, Eleanor, for a wonderful presentation today. We will be sharing the slides and a recording of today's call to everyone who registered. And Also, just a note as well that the Enroll Virginia Navigator team is available to help, kind of with individual cases or questions that come up for specific families who are trying to deal with whether they're applying for benefits or whether they're looking to keep and use those benefits. Well, thank you so much for joining us today. Thank you, Eleanor.